Good afternoon, ladies and gentlemen. Welcome to the panel sponsored by the Federalist Society's Administrative Law Practice Group. I'm Eileen O'Connor. I'm chairman of the Practice Group's Executive Committee. During this presidential campaign cycle, I keep reminding myself that the rules have changed. In previous elections, I was not especially concerned if a candidate favored a policy or two I considered unwise or unacceptable. He couldn't put it into practice unless Congress passed a bill and sent it to him to sign into law. A foolish or unwise policy would have to make it through Congress. No longer. When Congress refused to pass the DREAM Act, the current president unilaterally implemented it anyway. No law was passed by Congress. There was not so much as an executive order. It was just done. Fortunately, 26 states challenged the action. A United States district judge granted a preliminary injunction halting its implementation. And just last week, the United States Court of Appeals for the Fifth Circuit affirmed the injunction. When the current president decided he didn't like the lawfully enacted Defense of Marriage Act, he simply instructed his Justice Department not to enforce or defend it. The Justice Department is required by law to advise Congress when it has determined it cannot or will not enforce or defend a law. It did not do so. Just yesterday, because Senator Rand Paul was otherwise occupied and unavailable to prevent it, the Senate Foreign Relations Committee approved several international treaties involving information sharing for purposes of the administration and enforcement of tax laws. It's worth noting that to be approved, these treaties, again, they involve information sharing between signatory nations for the purpose of enforcing their own tax laws. These treaties will not become law for U.S. purposes unless 2/3 of the senators vote for it. But proceeding on the theory that a word means what he says it means, the current president declaimed that an agreement between the United States and another nation, under which the United States provides billions of dollars of relief from sanctions, and the other nation is permitted to develop nuclear weapons capable of destroying its neighbors and perhaps us as well, is not a treaty. If it were, it would require ratification by 2/3 of the United States Senate. Why bother? Turning the Senate's responsibility for ratifying treaties on its head, the Senate passed a bill acceding to the president's characterization of this treaty as not a treaty and decided the U.S. would be bound by it unless 2/3 of the senators vote against it. More of the same is on the horizon as the president attempts to close our enemy combatant detention center in Guantanamo Bay, likely as a prelude to handing it over to Cuba, and to surrender U.S. sovereignty to global climate change authorities and Pacific trade tribunals. But enough of that. We've entitled today's discussion, How Congress Can Reclaim Its Legislative Authority. But my subtitle for it and the question I ponder is, should Congress adopt a non-dereliction policy? Gathered before you on the dais this afternoon is a panel so distinguished and prominent it defies description. That was not a joke. In 1980, in a memorandum of points and authorities in support of a suit to enjoin an investigation by a special prosecutor, a young attorney wrote in part, "The Constitution charges each branch of government with the task of preserving its own essential powers in order to prevent frustration of the framers' basic design." 10 years later, that young attorney came to be known as Judge Randolph of the United States Court of Appeals for the District of Columbia Circuit. And in the 25 years since then, he has contributed mightily to American law. It gives me great pleasure to introduce to you Judge Randolph, who will introduce our distinguished panel and moderate their discussion. Judge Randolph.
Thank you. You know, this conference deals in one way with separation of powers, with concentration on what Congress's role is. And every time I hear of governmental powers, I think of Lord Acton, and he's always misquoted. What he actually said is, all power tends to corrupt. Absolute power corrupts absolutely. But my favorite corollary to that was by a columnist, Bernard Levin of the London Times, who's no longer with us. And he said, his maxim was, the less the power, the more willing to exercise it. And since I'm the moderator and I don't have much power, I'm going to exercise what little I have to to give you an introduction. Our topic in this particular session is about the expanding efforts of the executive branch and administrative agencies to control our economy and our everyday lives, and the diminished role Congress has been playing in protecting its constitutional prerogatives. There are many aspects to the problem. Congress today is fond of passing bills that are thousands of pages long. And these statutes, such as Dodd-Frank, the Affordable Care Act, the McCain-Feingold Campaign Reform Act, occupy vast fields, but Congress has neglected to keep them plowed. Representative Pelosi, as you all recall, speaking about the Affordable Care Act, bill, once said, we have to pass this bill so you can find out exactly what's in it. How many of the representatives who voted on that bill knew what was in it? And more than that, who would have guessed that, for example, an exchange established by a state meant an exchange established by the federal government? The disturbing truth is that even after Congress passes such a law, we will not know what's in it, and neither will the members of Congress who voted for or against it. We won't know because we have to await the actions of administrative agencies and their thousands of pages of regulation and guidance documents and interpretation of statutes, and then interpretation of the regulations they had already issued. The judiciary exacerbates the problem by granting deference to the agency's interpretation of these laws. I've never been a fan of Chevron. Matter of fact, I consider it a successful term of court if I don't cite Chevron even once, which on our court is rather difficult to do. I'll get a little technical. Section 706 of the Administrative Procedure Act did not apply in Chevron. The case arose under a provision of the Clean Air Act that did not incorporate the Administrative Procedure Act. And so, and maybe Chevron is defensible on its own terms given that particular context. But in case after Chevron, 706 of the APA did apply. And let me give that to you. It says that the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions. There's not a word in there about deferring to an agency's interpretation. It gives the judiciary the responsibility. And I think you can look at the cases that have been decided since 1984. You will find no mention of that statutory provision, which governs all the cases except those that are specifically excluded, such as the Clean Air Act. Well, I've gone long enough, and I've hardly touched the tip of the iceberg, which, by the way, is not melting. Our speakers today have a great expertise in the subject that we're dealing with. And our first speaker is Jonathan Turley. He's the professor of public interest law at George Washington Law School. Professor Turley has published dozens of articles in the country's leading law journals, and he has served as counsel in many of the most prominent cases of our time. He has served as a consultant on Homeland Security and also on constitutional law, and he frequently appears before committees of both houses of Congress. Our next speaker is Michael Uhlman. Professor Uhlman, or should I say Dr. Uhlman, teaches policy and politics at the Claremont Graduate School. When he was a young man, he was offered a scholarship to West Point, but he turned it down. He told me that anyway. Dr. Uhlman served as senior vice president of the Lynd and Harry Bradley Foundation and was a senior fellow at the Ethics and Public Policy Center. In addition to private legal practice as a partner in a prominent law firm, he was Assistant Attorney General for Legislative Affairs in the Department of Justice during the Ford administration, which is when Michael and I first got to know each other, and was also a special assistant to President Ronald Reagan. Our next speaker is familiar to you, Christopher Demuth. He's a distinguished fellow at the Hudson Institute here in Washington, From 1986 to 2008, Mr. Demuth was president of the American Enterprise Institute. He served in the administrations of Ronald Reagan and Richard Nixon. He's taught at the Kennedy School of Government and directed the Harvard Faculty Project on Regulation. Our final speaker is former Senator Tom Coburn. Senator Coburn served 2 terms in the United States Senate representing the state of Oklahoma and 3 terms in the House of Representatives. A proponent of term limits, he fulfilled his pledge in both occasions, each time not to run again. Senator Coburn, who was a medical doctor, became well known for his opposition to deficit spending and pork barrel projects and his leadership of the pro-life movement. So we'll begin with Professor Turley.
Judge, thank you very much, and thank you for the honor of appearing on this remarkable panel. As Henry VIII said to Anne Boleyn, I shall not keep you long. We have very limited time. But I wanted to touch on a few issues. But before I do, I have to add a disclaimer that while I represent the House of Representatives in the challenge to the ACA, my comments today are not associated with that case. In fact, I won't be talking about the case. And certainly not with a very talented legal team I'm honored to be part of. I'm actually here to talk about my academic work. And it starts with as a typical Madisonian moment that like any good 12-step program, it starts with admitting that you have a problem. And that's hard to come by in Washington. Part of the problem that we have is that we have a system, a beautiful system, designed by a genius that is changing, and is changing in a fundamental way. And I think it's changing in a dangerous way. And we're having no debate about it. There's no discussion. It's just sort of a national yawn as the system changes. And the implications for us is not my concern. The implications for my children really are the preeminent concern. We have, as Benjamin Franklin said, a republic if we keep it, and we're not keeping it. That moment was obvious in the State of the Union a few years ago when President Obama told Congress that he had decided he would go it alone and order unilateral actions. To my surprise, what followed was rapturous applause. You had half of Congress applauding wildly to the notion of being made functional nonentities. That's something, quite frankly, Madison didn't anticipate. He thought ambition would combat ambition. I suppose he didn't expect us and this generation. The question is, how do we deal with this? And I've come to the view, and this is the thrust of my academic work, I'm working on a book now that builds on some of my law review publications, is that I think that the problem that we're having, if we're going to turn this corner and try to return to first principles, is we have to stop dealing with the manifestation of the problem. We're constantly dealing with an immigration problem or a healthcare problem when it's far more fundamental than that. And we need to look at the real problem, which is structure, and that's the premise of my book, which is looking at the concept of structure. This idea of the separation of powers that Madison helped forge has been lost, partially because of the work of some of my colleagues. You know, we had the rise of functionalism in the academy, and it took hold in the courts, this idea, this move away from formalism. I'm a bit of a dinosaur. I believe in formalism. I believe in very clear lines of separation. I believe that Frost was right, that good fences make good neighbors. But I think that if you take a look at what we have seen with the rise of functionalism, it has been dysfunctionalism. Because the courts have followed this, current company accepted, judges have followed this functionalist approach. And they have removed themselves from separation of powers fights in defining the lines of separation. And that has caused the problem. My book basically looks at what I call a con-architectural approach to constitutional interpretation. It looks at the concept of structure and what it was intended to do. It actually borrows terms from architectural theory, including the idea of a deterministic design. And when I was reading architectural theory, it occurred to me it was a lot like what Madison was talking about, that the structure of our system is a deterministic design. It's meant to direct behavior. It's meant to affect us. And when we allowed those lines of separation to change, it was like taking rooms down, taking supports down in a system that was meant to funnel our efforts. And that has created the instability. When the courts removed themselves, when we went to this functionalist approach, we were left with raw politics. We took this beautiful mansion that Madison gave us and turned it into a one-dimensional ranch house. And the result is what we see, the stalemates and the raw politics in Washington. I was very taken aback when I read Winston Churchill said once about buildings in England. I read this when I had the pleasure of speaking at the 800th anniversary of the Magna Carta. And this quote was actually given to me by one of the speakers because we were talking about my book. And Winston Churchill said, "There's no doubt whatever about the influence of architecture and structure upon human character and action. We make our buildings, and afterwards they make us." That is what deterministic architecture is about. That's what the Madisonian system is about. It wasn't meant to dictate results. It was meant to dictate a process. It was supposed to form a way for us to resolve things that would be stable. In many ways, when you had constitutions, and it's plural because the French had so many of them, that were blowing up in the streets of Paris, we were stable. And that's because our system implodes. It implodes to the center of Congress. That's deterministic architecture. That's the value of structure. When you remove that, you remove the very thing that gives our system stability. So what I would suggest as an initial opening salvo in today's discussion is that while we will often talk about the manifestations of this problem, the deeper problem is that we've lost a notion of who we are and the architecture of this magnificent building that Madison created for us. And we have to return to structure and return to first principles. And I think you will find that much of the problems we have today will go the way that Madison thought they would. They will be directed to the center. We'll fight about it, we'll disagree about it, but they will be resolved in the way that he laid out. Thank you.
I have to comment when you were speaking about problems. I mean, I've often believed that in Washington, the main cause of problems is solutions. Professor Dr. Ullman.
Well, Professor Turley is more than usually right. We have to go back to the disease and not just to the symptoms of the disease. And the difficulty, I think, is that many members of Congress, both because of age, the younger ones especially, and the frustration of the older ones, even the better ones, or even the best ones, of whom we have a wonderful example here, feel very frustrated by the system and don't have time really to analyze the deeper aspects of the problem. The issue, if I can slightly change the title of our panel, is not can Congress remedy the deficiencies of the administrative state, is whether Congress can. Of course it can in some sense, but the question is whether Congress has the will and does it have the understanding to know what the underlying disease in fact is. And let me undertake, at the risk of some hyperbole, to state it in a single paragraph. The nub of the problem is that Congress has willy-nilly become the handmaiden rather than the rival of the executive by creating and maintaining a regime in which the rule of law has been displaced by the rule of bureaucratic experts. That's the problem in a nutshell. It's a long time to building. Its roots go all the way back to the thinking of Woodrow Wilson, and has been insinuated in the bone marrow of our Constitution over the past 100 years, exacerbated by the New Deal, aided and abetted by the judiciary, aided and abetted by Congress itself, and welcomed by all executives, Republican or democratic. At the end of the day, Congress today is essentially the ombudsman of the administrative state, a combination of Santa Claus and a distributor of regulatory rents. Almost all of what Congress does, with some exceptions, consists of those two activities. It gives away goodies, it creates exemptions to laws, and creates favors in the law, which is one of the reasons why these large pieces of legislation are so large. They're filled with special exemptions for special interest groups, different groups for Democrats and different groups for Republicans, but that's a large part of what goes into that legislation. Many members of Congress feel they cannot help themselves as a condition of getting reelected. One of the mischiefs of the administrative state is precisely that it creates this class of, two classes of tribes only in the United States, the Iwanas and the Gimmies. And Congress is in the middle of this and feels that in order to sustain itself in office, has to satisfy the Iwanas and the Gimmies by means of subsidies directly or indirectly, or creating exemptions or special benefits in statutory schemes. And then to compound the felony, when it comes to the substance of much policy, it delegates these tasks to administrative agencies, most of which fall under the aegis of the executive, and then it complains about administrative overkill, executive bloat, and caprice. This is not what James Madison had in mind when he helped to create the Congress. Congress does almost everything except legislate in the old-fashioned and substantive sense of that term. Of course it legislates, but not in the manner that Madison contemplated, which consists of instructing members of Congress about their duties to deliberate about the clash of factional interests in the body politic. That's the essence of the legislative function. That deliberative activity takes place primarily in committees for complicated reasons, which we needn't go into at the moment and don't have time to in any event. Over the past 30 or 40 years, Congress has disintegrated the internal mechanisms by which that deliberative process takes place and educates members of Congress on the one hand, and on the other produces legislation that's much more moderate in character and has some efficacy in its potential to cure the problem that's being addressed. I call for the restoration of the regular order. That phrase is much endorsed by the leadership in Congress, especially on the Republican side. It's seldom done, but at least in principle it's endorsed. But by the restoration of the regular order, I mean not only in respect of spending and taxes and the accumulation of actual appropriations bills as opposed to governance by continuing resolution. I have in mind the restoration of the Madisonian order in the proper sense, and that means re-empowering legislative committees and committee chairmen, and that in turn will require repealing some internal rules that over the past 30 or 40 years Congress has enacted, the consequence of which has been to shift a large part of legislating power to the Speaker's office on the one hand and the Majority Leader's office on the other. There are technical reasons for this. I understand the reasons for it, but I think it's terrible in the long run. It's one of the things that makes Congress self-defeating in its efforts to pass intelligent legislation. You've got to get the committees back in this game as substantive legislating bodies. You know who understood this? Woodrow Wilson. In his dramatic attack on the separation of powers in the 1880s, in his first published book, he attacked Congress precisely because of the committee system, because it was in the committee system that the Madisonian factions competed with one another, and that he didn't like because it was too much competition, number one, too much inefficiency, number two, and number three, it produced results that philosophically did not comport with the progressive ideal. He and other experts like him knew what needed to be done. It was a function, he said, of expertise. In his famous essay on administration, he argued that the essential problems of government have essentially been solved. All that remains is administration by neutral policy experts. Welcome to the administrative state. His attack on Congress focused precisely on committees, which he attacked somewhat disingenuously as being parochial. What Congress needed was leadership from the outside to be provided by a president armed with new rhetorical powers, and through the device of party government would whipsaw Congress into becoming, as I say, the handmaiden of the executive. And lo and behold, the history of the past 100 years, with variations, is essentially that. The progressive ideal has dominated American politics almost ever since, on both sides of the aisle, including but not limited to Newt Gingrich. His disposition as Speaker of the House was very much Wilsonian in its attitude toward public policy, the centralization of authority, the gutting of committees, and impatience with that Madisonian bargaining and giving and taking, which produces very different kind of legislation than you can impose from the top down. Enough of pathology for the moment. Let me turn to some remedies other than re-empowering committee chairman, if I can see with this wonderful light we have here. Brother Demuth, may I have your light? Yeah. I'm proud of you. Good. Good. Oh, yes, much better, much better. Oversight. Congressional oversight is at best these days ad hoc, haphazard, and ineffective. It's not that hard to do if you know what you're doing. Connected to that is very much re-empowering legislating committees. When you know the subject matter, you know how to conduct regular oversight. Oversight could begin, for example, not just with investigations of wrongdoing. It could begin with a systematic examination of extant policies in a particular area, energy, environment, whatever it is, to make any difference. Have the committee look into what they have already enacted, what the current state of regulation is, and to reassess it toward the end of reenacting legislation or not reenacting legislation pro bono publico. That work has to be done in committees. It can't be done from K Street. It can't be done in the leaders' offices. It has to be done in committee. And it's one of the ways, as I say, that individual members of Congress in both houses are instructed in the arts of drafting legislation and the difficulty of doing so. It also instructs them in the art of Madisonian compromise. Madison was dead right when he said that liberty is to faction as air is to fire. You solve the problem of faction not by imposing a set of values or opinions from the outside, by letting 1,000 flowers bloom and pushing it into Congress and forcing Congress to deliberate about the splits among these factions and which of them will in fact work pro bono publico. That work has to be done in committee. It can't be done by agencies, and it can't be done in the leadership offices. Congress needs to increase both quantitatively and qualitatively its brain power. There are wonderfully intelligent people in Congress, one of whom, again, is sitting in front of us here. But Congress has, in many respects, gutted its intellectual capacity by diverse rules changes and by gutting those institutions within Congress that would provide some distance on what's going on. You cannot hope to compete with the executive branch with its built-in 10-deep expertise in every agency with the kind of staffing Congress now has. Over the past 15, 20 years, Congress has systematically reduced the size of committee staffs. Much congressional staff is now devoted to serving the social service state. They do casework much more so than they do substance, which was not true 30 or 40 years ago. The GAO and the Congressional Reference Service, believe it or not, are 20% smaller than they were in 1979. This is penny wise and pound foolish. That kind of intellectual expertise has to be built up in a whole variety of areas. I'm in favor of Congress having to create what, want for a better term, I call internal think tanks. It can be as specialized as Congress may wish, but why shouldn't Congress have a body of congressionally loyal experts, just the way agencies do, devoted to a particular subject matter of importance, so that when Congress, before it delegates to an executive agency, so to speak, delegates in-house to its own experts to find out what the consequences of a particular proposed piece of legislation might be. One would have to be cautious about how you do this. You would have to relate it to committee jurisdiction, which brings me to my next point, and that is the revision of committee jurisdiction. That issue has not been revisited in depth and systematically in a very long time. It has to be done in a way that comports with the existence of actual government downtown. There'll be all sorts of broken china, I realize in this, but if Congress wishes to play, it needs to play intelligently and hard. One final point, Congress can and should revisit the Administrative Procedure Act. It's an interesting piece of legislation. I tear only one small page from its political history, which you normally will not read about. It took 10 years for that legislation to come out. It was a roiling battle in Congress from about 1936 or 7 until 1946. Not for the first or last time, the Democrats stole a march on the Republicans. They realized, and they effectively predicted, that they would lose the election in 1946 congressionally, and they feared they would lose the presidential election in 1948. One of the things they decided was to institutionalize the reforms of the New Deal by institutionalizing the rules that had so far been embedded in the then burgeoning administrative state. We have our judges in the courts. We have our administrators in the agencies. The courts will defer to the rulemaking by the agencies. Our people are there. Let's lock it into statutory form, and that's what they did. That whole issue needs to be revisited. It's the ultimate godfather of Chevron. It's the ultimate godfather of all sorts of mischief inside agencies. Lots of interesting things could be done in rewriting the APA, and I hope it's done. I hope Congress has the brain power and the patience and the longevity to address it and do it right. Thank you.
Congress is delegating lawmaking authority to executive branch agencies and acquiescing in legislative seizures and presidential seizures, agency seizures, are longstanding phenomena. They have deep causes, political, cultural, institutional. A necessary condition of constitutional restoration is restoration of a Congress that is once again jealous of its constitutional prerogatives and capable of exercising them vigorously. That is going to be a long and difficult task. Professors Turley and Uhlman have mentioned some of them. Others are being examined in the morning Article 1 panels at this convention. To sharpen the dilemma, I would like to assume that Congress does indeed pull up its socks, get its act together, step up to its constitutional responsibilities, and ask, what practical difficulties would our dream Congress then face in reestablishing legislative primacy over the machinery of executive lawmaking that its predecessors have created? Following Professor Turley's emphasis on structure, I would like to review three basic structural approaches that this Congress might attempt. The first is full-force irredentism, Congress reclaiming the lawmaking territory it has ceded through direct legislative action. Professor Philip Hamburger, in his book, Is Administrative Law Unlawful?, answers that question with an emphatic across-the-board yes. If you press him, he would say that our dream Congress ought to convert the entire code of federal regulations into statutory law, soldiering through dozens of chapters, adopting, abolishing, and revising specific provisions as it went along. But the CFR is over 150,000 pages. It is over twice the length of the United States Code. So this process would take many decades at a minimum. Moreover, the Code of Regulations is growing at a faster rate than the Code of Statutory Law, so Congress might never catch up. More realistically, Congress would focus on statutes and regulations of immediate political salience or rules agency programs that had strayed particularly far from popular sentiments. In the real 114th Congress we have today, The majority Republicans say they want to repeal and replace Obamacare. They want to do about the same for Dodd-Frank. They're terribly unhappy with the ways that the Clean Air Act and the Federal Communications Act are being interpreted and applied, but there has been virtually no legislative action on any of these fronts, nor have they even taken the initial step of displacing many specific congressional rules, and there are many at the Federal Reserve Board, the Food and Drug Administration, the Labor Department, the Office of Civil Rights, and the Education Department, where they could attract substantial Democratic support. The standard demur is that action must await a new president in 2016. That is itself an acquiescence in executive supremacy. But even for our dream Congress, rewriting the 4 major statutes I've mentioned, with or without the collaboration of a reform-minded president, would be a Herculean task, and yet it would leave most of the work of the executive state untouched. Executive law is so vast and protean and is so deeply entangled with private society and commerce that even an assertive, cohesive Congress could affect its course only gradually and incrementally. The second approach is to amalgamate legislative and executive law through something like the Reins Act, which would require major rules to be submitted for congressional approval or disapproval under expedited procedures and prompt up or down votes in both chambers. The Reins proposal follows successful precedents in the military base closings and trade liberalization exercises. I believe it has many appealing properties, especially in balancing the executive advantages of specialization and missionary focus with the need to assemble 2 majorities of diverse, popularly elected generalists. But Reins has problems, and even if they are solved in the hands of a dream Congress, it is going to affect only the bow wave of the forward-moving executive ship of state. Nobody thinks it would be practical for more than a few dozen major regulations per year. The standard threshold is $100 million of economic effect. Even if we set it so there would only be 10 rules affected per year, think what that would mean. It would mean that the president could routinely commandeer the legislative calendar with complicated, costly surprise bills arriving at moments of his choosing, which is a problematic way of confronting the executive branch. I think that we could correct these problems in the current Reins proposals by removing expedited procedures and providing that Reins-submitted bills have to go to the authorizing committees of jurisdiction. In fact, our dream Congress might insist on that. It is a staple of congressional reform, something that Speaker Ryan is also already beginning, that the committee structure has to be greatly strengthened. But notice that the closer that Reins approximates regular congressional order and procedures, the greater is the tension between efficient, missionary, specialized executive lawmaking and slow-moving, consensual, conflict-riven legislative lawmaking. The third approach is a new legislative executive détente in the form of a revised Administrative Procedure Act that would tighten agency procedures, standards of judicial review, and limit agency discretion under the organic statutes. There are 3 big standard reforms in this area. The first is to take some major categories now conducted through 553 informal rulemaking and impose on them requirements for live adversarial proceedings with testimony, cross-examination, the cut and thrust of lawyers' arguments, and most of all, court-like standards of evidence. The second would be to move the administrative law judges who would be conducting these new formalized rulemaking proceedings as well as adjudications out of the agencies whose cases they decide and into an entirely separate and independent office. It could even be part of the Congress, from whence they would ride circuit around numerous agencies. And the third is to somehow reiterate the provision of the Administrative Procedure Act that Judge Randolph has quoted. Maybe we could put it in bold font, that says that upon appeal, it is the responsibilities of Article III courts to decide questions of law. Now, I have to say that formalizing procedures such as these have been a constant of the administrative law debates going back almost to the APA's founding, certainly to the early 1950s. Congress has never enacted any of them, with one tiny exception in the mid-1970s. Professor Uhlman has given reasons to think that the current Congress would not be up to the task. I'm not so sure. Our hypothetical dream Congress, faced with the inherent limitations of the two other approaches I have suggested, legislative displacement and legislative executive amalgamation, would be bound to consider supplementing whatever it did in those areas with across-the-board strategies such as APA reform. Our real 104th Congress seems to be pursuing APA reform much more seriously than either statutory rewrites or reins. If that is because it is not our dream Congress, that it is not yet willing to step up and make hard policy decisions for itself, all the more reason to focus on administrative law reforms while working on the longer-term project of congressional restoration. One reason Congress is interested in the APA these days is that the regulators have been slipping even the very loose leash of 553 informal rulemaking through such ruses as the Office of Civil Rights specialty, which is making major, actually radical policy through informal guidance and dear regulated colleague letters, and the EPA's specialty in setting very tight effective date deadlines for costly policies with long lead times, which has the effect of mooting judicial review, as it did in the Mercury rule that the Supreme Court wrongly thought that it decided in Michigan versus EPA back in July. Congress should certainly remedy these immediate abuses, and while it is at it, it might move on to other reforms such as I have mentioned. And in that spirit, I'd like to conclude with a pitch in the category of APA reform for adding to the Act a judicially reviewable benefit cost standard, so that on review, a court would determine not just negatively that the rule was not arbitrary, capricious, or an abuse of its discretion, but positively that the agency had made a reasonable demonstration that the benefits of the rule would exceed its costs. This is policy, not procedure. For the rules affected, the standard would address the delegation problem directly by instructing agencies how to exercise their discretion under the organic statutes. Here are three advantages, and then I will conclude. First, the cost-benefit standard, like Reins, has the advantage of some precedent. Every president, from Ronald Reagan through Barack Obama, has had an internal executive branch policy for regulations that is a cost-benefit standard, augmented by the requirement that agencies choose the rule with the greatest net benefits. Standards such as this have been adopted by one or the other House of Congress in several statutes over the years, once by the Senate in 1982 by a vote of 92 to nothing, and Congress has added similar type requirements to specific statutes such as the Securities and Exchange Act, the provision that was decisive in the D.C. Circuit Court's decision in Business Roundtable versus SEC in 2011. That shows us that a benefit cost standard is politically feasible, that it has some appeal across partisan divides. Different legislators will have different views. They will want more aggressive and less aggressive application of different statutes, but a good many of them will be content with an across-the-board rule that all statutes be applied in a cost-effective manner. The second, such a rule, judicially reviewable, would transform the role of the analytical staffs within the regulatory agencies and between the agencies and OIRA, as they have been under the executive order programs. Under those programs, OIRA and the agencies, people within the agencies often disagree on the merits of rules, but when a decision is made, everyone is on the same team and lines up and salutes, and the OIRA is often overruled for political reasons. These problems have become much worse in the Obama administration, where benefit cost analysis has been converted essentially into a public relations tool. If you go to the relevant pages on the websites of EPA or the Department of Energy, you will feel that you have arrived at something like a propaganda ministry, which, among other things, uses highly debatable, sometimes preposterous evaluations of benefits and costs, actually to snuff out serious debate. The prospect that these assessments would be reviewed by independent courts could convert it into a serious decision-making tool and moderate these abuses. And finally, not all rules, but a substantial subset of them, not all rules can be effectively governed by a benefit cost standard, but many, many can, involving health, safety, environmental, financial, and commercial regulation, and that's a lot. Today, there is a substantial scholarly literature on how the agencies assess the economic impact of regulations in all of these fields, a literature that is often highly penetrating and critical and completely nonpartisan, but it is strictly academic. It is not a professional literature in the manner of law review critiques of legal cases and doctrines that are part of a conversation that includes judges and law clerks and over time affects the actual path of the law. The aim of a benefit cost standard would be to professionalize regulatory law to some degree, much as the shift in antitrust doctrine in the 1970s and 1980s professionalized antitrust enforcement, and as, according to some recent research, is now happening provisionally, at least at the SEC following the Business Roundtable decision. In sum, recognizing that a large body of delegated lawmaking discretion is going to be recovered only very slowly, if ever, even by our dream Congress, this and many other APA reforms could be a high leverage strategy for making executive law somewhat more balanced, public interested, and respectful of private rights and commerce. Thank you.
Well, since I'm the only doctor on the panel that's of a medical training rather than legal training, I will stay here. Usually I'm the person that passes out Prozac after we have a speech, but I'm already depressed from what I've heard. I will just share with you shortly my insight on what I've heard. We heard you can't treat the symptoms, you got to treat the disease. And I think that's right. But I think the disease is a whole lot different than what we've heard today. The disease is a decline in the recognition of where our freedom comes from, inside Congress. The disease is the failure of human nature to put others ahead of yourself for a higher good. The disease is lack of leadership of people who will call you to a higher purpose so that you can accomplish greater things. So I agree, we have to treat the disease and not the symptoms. The disease is, and many have called me naive through my life. I like that. I am naive. I actually believe we can cheat history in our country. But I don't think we're going to do it through more regulations in the Congress. I think it has to change who we send to Congress and what they're made of. I'm impressed that the vast majority of the Senate has never had a job outside of politics. That certainly doesn't make them bad individuals, but they certainly don't have any broad view of things or a spectrum. And I spent 16 years in the belly of the beast. What I saw was rationalization and expediency rather than courage and honor. And I'm not talking about any one party. And so a lot of the recommendations, I agree. The first 2 years I was in the Senate, I had 46 oversight hearings. We passed the law that said the GAO had to report duplication and waste. There's 400 billion of it every year. I left the Senate early, Your Honor, because I was frustrated that nobody wanted to help do anything about it. And the rationalization of the politicians was, well, the big problem is really just the entitlement programs. There's nothing wrong with all the rest of this. All the rest of this is one of the reasons that we're bankrupt as a nation, and I would say our politics is bankrupt because our long-term viewpoint is about the next election, not the next generation. And as seen in this administration, you see the rule of men instead of the rule of law. And so I think we tread on, and I'd mention one third thing and then I'll be quiet. We're at a turning point in our nation. I've been in 26 states this year. There is about to be a major cultural shift in the foundation and the moorings of our country, and that's the millennial generation. They don't understand liberty. They have no knowledge of our history or the sacrifices. When Pew Research looks at them, 68% don't trust the federal government, but almost 60% want more of it. That's the definition of schizophrenia. So I think we're really at risk, and I think we have to get much, much sicker before we're going to get better. I think the American people are wildly smart and intelligent as a group, and I think they don't get good representations for the people that they elect. And that's a pretty dour, cynical viewpoint, but I've seen it up close and personal. And I've heard the people say privately, you're right, but it might affect my election. I'm not going to do that. What is that about? And the Madisonian, I use Madisonian principles. I blocked more bills than anybody could say based on Article 1, Section 8. Even as interpreted by the Supreme Court. And those that really wanted to get something done would compromise and we'd pass a bill. Those that didn't want to get something done, they just complained about somebody blocking their bill. So I think we have a long way to go. I think we're at great risk. And I think there are some things Congress can do, but the number one thing we have to have is good leadership. And maybe Paul Ryan's that answer in the House, but I think we have a long way to go until we meet the potentials that we all aspire for, and we ensure the freedom that has been paid for before us.
Before we turn it over to questions from the audience, I wonder if any of our panelists would like to comment on something that another panelist said.
I'm happy to.
Yeah. You're fine? Okay. So I guess we'll open it up to questions.
Could I say one thing?
Sure.
In response to Senator Coburn's. Here we go. How's that? Is this working? I want to say one thing in response to Senator Coburn's stirring remarks. I agree with him, but this isn't like a senator talking about energy policy. I'm for all of the above. Let's try all of the different things. I believe that the role of leadership is important, is critically important. But there is a division of labor, and the three people on this side of the table are not political leaders. We're thinkers and scribblers. And to say simply we need moral rearmament and better leadership it's not a very satisfying or productive thing for us to do. What we mainly do is analyze problems. When we come along to solutions, that's often the least interesting thing that we write about. But when we write about solutions, it is for the benefit of leaders who might make use of them. Dr. Coburn was a senator and a representative legislator, and in that role was a tremendous leader. Paul Ryan seems to have the stuff where he could be an important legislative leader. That is practical work, and it is different from the kind of things that we do when we come up with comments such as that we have provided. I think of the work that we do as building up a storehouse of analysis and ideas that may be used by leaders in the arena, in the sweat of the arena, either far-sighted leaders who can see problems coming and do things before the crisis, or what is more typical in the American system, wait until there is a crisis and the walls are falling down and are desperate for ideas of what to do about it. So I think that the three of us are a little bit different. We're not saying Congress must do this, Congress must do that. There is a range of things that can be done, but the actual deployment of those ideas is a matter of practical work for practical politicians and a job for leadership such as the kind that Senator Coburn has shown so brilliantly.
Here, here.
Mine was not to be critical of the suggestions that you made.
I know.
I'm just saying there's a real absence. There's a real hole. And I'm not talking about the leadership inside the institute. I'm talking about the members. I mean, this is my paraphrase of Martin Luther King. Cowardice asks the question, is it expedient? Vanity asks the question, is it popular? But conscience asks the question, is it right? Well, I think there's a lack of conscience, public and personal, that pervades Congress and in both parties, because the number one thing is the team of the party, not the team of America, not the team of our country, not the team of our future, not the team of our kid. And that's normal human behavior. But somehow this country for 150 to 160 years had statesmen that would deny that one human degradation and defect and stand against that to make a difference. And that's what we don't see today. There's exceptions to that, but that's what we don't see today. And so my frustration, the reason I left, is I wanted to go try to do something different. And I love Article 5. If you all want to help me do that, that'd be great too. But I think that's the answer, because I want to scare the hell out of Congress. If we get close to 32, 33 states that have made application under Article 5, they're going to start doing what their oath says they'll do, instead of run for re-election all the time.
Yeah, I have a question. I wonder if you would agree that one of the distortions as a result of the current system is that when anything happens that's controversial and people take sides, that the aim is not at Congress, but at the agency that implemented it. We hear criticism of EPA, we hear criticism of the NLRB, and so on and so forth. When in fact, most of the time they're operating within these very broad delegations of authority that Congress has given them. And so the current system in legislation is a method for Congress to evade its responsibility and not take blame for mistakes that are made. And I wonder if that's been your experience.
I think I think that's true to an extent, but I think the other big problem with Congress is it's lazy. You can know the answers to what you need to know in legislation if you want to work at it. We have, I would defer, we have plenty of money in a Senate office. I didn't spend all my money on constituent service. I had some of the best staff in Washington, and they weren't the highest paid, and we turned back almost $1 million every year. So the fact is they don't want to do it because they'd much rather be doing the fun things of politics rather than the sacrificial leadership that's required if you're actually going to make changes that are good for the country in the long term.
I guess the only qualification I would make of that, and I certainly, it resonates with me, everything that was said, But there is a natural limit of what Congress can do with the size of the federal bureaucracy. We have the rise of this fourth branch that is increasingly independent in a way that wasn't anticipated by the framers. And I think it's certainly true that politicians often like it when other people make tough choices. And so they give broad decisions. They don't like making the choices of you get X and you get Y and you get nothing at all. And so they kick that can down the road. But I think we're deluding ourselves. When you look at the size of the fourth branch, it is really impossible for Congress to make a meaningful oversight record with these agencies, certainly at the size that Congress has. I happen to agree that they need to increase the size to have any hope of reviewing these agencies. But I think that what you're seeing, and I think this really touches on what the judge said, is not only is there a tendency to kick the can down the road, let the tough decisions being made by these agencies, but the nature of the issues are changing. I mean, we're not only becoming more of a ministry system as in England, but you look at decisions by agencies and you can see the nature of the questions are changing in a dangerous way. To give you a very small example, the Redskins name is a very good example of that. I mean, here you have a question that is heavily invested with social, political, cultural issues. Who would have thought that a small agency would answer that question, would resolve that question? One that is just an entirely single moving part that's operating on its own, this teeny little board. And I think that's the true danger here, is you have the rise of a fourth branch in a tripartite system that is insulated not only from Congress, it's somewhat insulated from the White House.
My answer to that is if that's true, we're dead already. If what you just said is true, we're dead already. There is no, what you're saying is we cannot compete with the fourth estate to bring it down without adding more money and more people.
No, I think we can. I think we can, but Congress has to be more aggressive.
Right, and so where are you going to get the congressmen that are going to do that? Because the reason you see Donald Trump and Dr. Ben Carson at the head doesn't have anything to do about competency. It has everything to do with trust. And you can lead on hard issues. Our problem is our politicians won't lead on hard issues because they're afraid they won't get reelected. The greatest honor in the world is to lose elections standing on principle. That's the greatest honor. It's not to win one. And what we lack today is the courage of those that came before us. Our politicians are weak today in general, in my opinion. I mean, why would somebody get upset if you really believed in the Constitution and you wanted to stop bills in the Senate based on that? Think about what that says about who's in the Senate. You can have a debate. They wouldn't even debate. I mean, look at the Senate. How much real debate have you seen in the Senate or in committees? Watch C-SPAN. There's not a real Socratic debate. There's an abandonment of what Moynihan said. You can have your opinion, but you can't have your separate facts. You don't even see that. Matter of fact, nobody would debate me when I left the Senate because they didn't want to debate. They wanted to just let the process roll. And so what I say is we need a renovation, not just of the heart, but of the morals that lead to great leadership in this country. And we need to get rather smart about who is in the Senate and who is in the House. And it's not the political nature. And the question is, with the economic time bomb that is in front of us, $142 trillion in unfunded liabilities. By the way, CBO and OMB lie every year about where we are. With what's in front of us, how much time do we have to cheat history? And I want to cheat it. But we're not going to do it with the leadership that we have today across the Senate and across the Congress, and in the agencies and in the executive branch, and oftentimes in the judicial branch where they take the easy way out rather than taking the hard way.
Okay, we have many people lined up for questioning. I don't know who's first, but...
Hi, I'm Michael Houston. I practice administrative law at Gibson Dunn. I appreciate the panel's suggestions for how we might reform Congress and for Dr. Coburn's suggestions on how we might change the people in Congress. I'm curious if you all think that's really where we should devote our resources, or will real change only come when we focus on electing a chief executive who is committed to a much more limited constitutional role for the executive branch. Do we need to make the administrative state an issue in this upcoming presidential election and all future presidential elections? And if so, how do we do that? Thank you.
Well, I have to say I'm skeptical because, presidents come into power all the time, including the current one, saying that they want to see limitations on executive power. That was the campaign of this president. And as soon as he came into office, he decided that, this is an abuse by others, but I'll use it wisely. And I wouldn't count on having a savior as president of the United States because, unfortunately, experience hasn't exactly supported that view. What I do think we can do is it's essential for the courts to mind the line of separation and to accept things like legislative standing. The reason we're in this pickle is that the courts removed themselves and there's not a definition of who makes decisions. And so they have these constant fights as they try to usurp each other's power, and courts use this excuse to remove themselves from the process. If they actually start to mind the line of separation and say that, to be clear, who makes certain decisions, members won't be able to kick the can down the road. You'll see more members going and saying, look, this is our authority. I talk to members all the time who want to see changes, but it's not going to happen if there's no one to enforce it. So you can have every member of Congress who believes in the Madisonian principles. If there's not a court that's going to listen to a constitutional challenge and mind the line, well, then this is, frankly, the day is over. But once that happens, I think you'll see changes.
Well, there's a role for everybody in this business. We live, for good or ill, in a presidential nation. This is one of the consequences of the progressive revolution. Only presidents at the moment can define an issue of national scope, and you absolutely need that. As Chris well knows, when President Reagan ran for president in 1980, regulatory reform was one of his targets, and there was a group of us who worked systematically on this. I don't think any of us thought it would be a magic wand, but boy, it did some good. We slowed the rate of production of regulations. That curve flattened out. It didn't do everything we wanted to do, and we certainly needed more. But at the time, it was an interesting way to address the issue, and it's one that was very close to the president-elect's heart, to the candidate's heart. So it's not impossible. I think there's all sorts of things presidential candidates could do. Some of us have kicked around the idea of, aside from Mr. Trump's crudity, I mean, his instinct is ferret-like, and it's interesting. And he certainly got public attention on it. But there's all sorts of regulations out there that are sitting ducks, and how encouraging it might be for a presidential candidate to say, such and such a regulation, take that god-awful HUD housing rule that would impose diversity criteria on zoning regulations from the federal government with no legislative authority to speak of. Suppose a presidential candidate, there are other targets, I don't mean to emphasize that one, you simply say on January 20th, 2017, that regulation is bye-bye. It will no longer be enforced by my administration. If Congress wants to enact it, let them reenact it. You could take a half a dozen issues of that sort that are hot-button issues in the body politic for a conservative Republican type constituency, identify them through the voice of the presidential candidate, and force Congress into this game, but alerting the public to the fact that it knows something already, but here is a particular target for you to focus your anger at. I think that is entirely feasible, and it's a way in which you get the problem of the administrative state roiling the public in a way that's useful and not merely one of venting about what we're not doing, for example, about immigration.
I am an incrementalist in the sense that I think it's important to work upon problems that are immediately at hand rather than sitting back and saying, well, if I were God, how would I move resources around the nation one way or the other? And there are a lot of particular things that can be done to improve the situation, and I focused on several of them in my talk. I think the question of the presidency is particularly acute and interesting when it comes to the reform of the executive state, which formally reports to this individual. Most resources in politics today go to the president, reflecting the all-powerful nature of the presidency. If you look at the length of campaigns, the amount of resources devoted to campaigns, there's been an enormous shift from the legislature to the executive branch. The money has been following the power. When one is working on the question of a national campaign to be President of the United States, you do, and I have advised, including this time around, several people who were in these sweepstakes, you do not talk about anything we're talking about here today. People won't have the slightest idea what you're talking about. The person who's done it best, there have been others, but the person that did it best was Reagan. He did not talk about regulatory procedures or things like that. He gave specific examples of regulatory outrages which dramatized the insularity of Washington and its propensity to pursue things that essentially everybody thought was stupid. And there are lots and lots of those examples. That's what you do at the level of presidential leadership. If we do get to a point where there are different thought experiments, but imagine that a reform-minded Republican president comes in a year and months from now, and the 115th Congress is Republican. One of the great threats is that this process of delegation and broad discretionary lawmaking will continue, because everybody will say, well, my good friend President Rubio is in charge downtown, so we'll just say something nice and he'll figure it out. And there'll be a level of trust that will actually work toward a further waxing of the executive state. At some point, we're going to have to have a point at the beginning of an administration where a president realizes that the executive branch that he's head of has become just too damn powerful, and even too powerful for his own political good. And that we need to have a new treaty, a new establishment of structural relationships between the branch that he is temporarily head of and the other two branches. There is a sense in which especially the Congress faces collective action problems that only presidential leadership can overcome, and that could be an important responsibility of a president in some perhaps somewhat immediate circumstance.
Okay, next question.
So much of what you all have discussed, and especially you, Senator Coburn, really points out a concern that I've had for quite some time, which is there's a cultural problem here where especially the younger generation doesn't even know what it means to be free. We have people at campuses today fighting against freedom of speech, a fundamental right. And as you've traveled, I'm just curious, aside from getting the right candidate to do the right thing and coalesce a country around the right message, how do you fundamentally get in there and start reteaching this? Are you seeing bright spots across the country where you think that eventually we'll get those leaders back up here, more of them than less of the ones we have now?
Oh, I think the only way you get back there is re-embrace the vision of our founders. They wanted a limited federal government. I mean, think about what Thomas Jefferson said about education. Federal government can't be involved in education without an amendment to the Constitution. We've spent $3 trillion on education since 1976 from the federal government, and 60% of every state's budget of their own money that they've raised is now ruled by federal bureaucracy, and yet there is not one measurement in education that has improved since 1976, and many are worse. So why are we such slow learners? These guys were wise, and they said, you need a limited, you need government where it's closest to the people, you need it where you can have some action. So my hope is that we would actually get aggressive if we want our children to, regardless of the economic consequences that are coming, which is $1 million per household in terms of unfunded liabilities. If we want our children and grandchildren to experience and taste what we've experienced and tasted, what we have to do is re-embrace the very genius of what this country was founded upon, which was a limited government. There's nothing limited about this government. Matter of fact, isn't it ironic that they talk about before the shutdown that only non-essential employees will still be working? Why the hell would we have anything except essential employees? So that's funny, but it's so terribly damaging. You know, the Department of Economic Analysis, just, you know, this is a populist trick, but it's true. Just put out the study on federal employees. The average federal employee makes 72% more than everybody, fully absorbed, than everybody else in the country on average.
Except judges.
Well, we actually need to pay the judges more, certain ones of them anyway. And they make 52% more than state employees. But think about it. Why would we have that disparity in terms of government? When I was growing up, working for the government was service. And now it's elitism. And so we've lost control. The question is how do we, who believe in the fundamental principles of this country, restore it? How do we cheat history? And we're not going to be doing it with the exact same, sending the same farm teams to Washington that have the same moral ethos, which is the other side of it, is, you know, people are embarrassed to talk about faith. Faith is a component of doing the right thing. And knowing the ethics. I had a visit with one of the professors here earlier about who's teaching ethics at the University of Virginia. We don't teach ethics anymore in schools. And it's certainly not being taught at home. And what you see in terms of the media, there's not much there. So how do we do it? We re-embrace the principles that made us great. And we don't rationalize what the real problem is. The real problem is every other republic has failed. That's the problem. And how did they fail? Exactly what we're doing. So why would we keep doing it?
Is there a microphone back there? In the back?
Nobody's there. Nobody's there.
Oh, okay.
Yes, Roger Pilon with the Cato Institute. I want to pick up on the points that Senator Coburn is making and speak from personal experience, because in 2005 you held hearings, Senator Coburn, on whether Congress had the authority to do all that it's doing. 4 of us testified, 2 senators showed up.
Yeah.
So much for the interest in Congress.
My point's made.
Absolutely, that's right. That's why I made it.
The check is in the mail.
But it's not only Congress, it's the courts as well. Justice, and this is picking up on Chris Demuth's point about incrementalism. The court had 2 cases this term, the Perez case and the Amtrak case, in which these issues came up. In Amtrak, the court ducked it by saying that it was a public organization. In Perez, it had before it one of the 3 deferences, namely, you've got, you talked about Chevron, you've got Skidmore, you've got our deference. And here too, Scalia rails against our deference, and probably there are 3 votes to revisit, but the court simply will not visit these judicial, deference, congressional deference issues, or judicial deference, excuse me, issues. And I wonder what you would have to say about what it's going to take to have the court finally revisit these 3 forms of deference, especially the most abused, our deference.
Well, I think that the Supreme Court and our court ought to face up to the fact that we've been operating in violation of the APA, of the Administrative Procedure Act, Section 706. Nobody's really confronted that, and I read it to you, and so did, I think, was it Michael? Yeah, and maybe there's a way that you can read Chevron into that, but on the face of it, I don't believe so. And you know, it's one of those things that there's precedent, but you know the word I hate, or the phrase I hate, is prior precedent. But I don't know why that. Well, it comes to mind because we had an oral argument. I asked the counsel. I said, "Is there any other kind?" But the precedents are really not all that powerful because they've really never faced the Section 706 question. Anyway, John.
Matthew Mimno. I'm currently a law clerk. My question is regarding the beginning of the discussion. What do you make of the argument that committee work doesn't actually result in deliberation and compromise, but too often results in sort of stalemate and the status quo and a minority of each respective caucus sort of obstructing things? And I think what Woodrow Wilson in congressional government was talking about, for an example, was during the Gilded Age, you had long committee chairs that were bought and paid for by the sugar trusts and the rail trusts and the oil trust. And a more modern example would have to be in the early 1960s during the Kennedy administration, when you had party caucuses in both chambers that were indeed eager to tackle civil rights legislation, but because you had Richard Russell and John Stennis and a bunch of Southern oligarchs on the committees that had held those committee gavels for a long time, no civil rights legislation was going to get through the Rules Committee. And too often the committee structure is one that sort of, promotes that sort of obstruction rather than deliberation.
Well, there's no perfection in this business. I think my point was a different one. Yes, restoring powers of committee chairman has vices, no question about it. I think Congress has overkilled it by gutting the committees. The only way Congress can legislate in any intelligent way is in committee. Part of the solution in recent years is to do the substantive legislating, to the extent it takes place within Congress, in the leaders' offices with a small group of allies of the leadership, rather than through the committee structure. It's a question of balance, surely, but the more you empower committee chairmen, and there's vices to that, as I say, the more you give them the leverage to bring those factional differences together, and you can produce reasonably favorable legislation. It's not going to work every time. What's the alternative? To have the executive branch write the substantive policy, or to have it put together by a cabal in the leadership offices without that Madisonian give and take among factional differences? There's no way around that issue if you want to have legislation that in fact is workable, than doing it through the work of committees. Wilson, as I say, understood this. He understood it perfectly well. We do not. We do all our substantive legislating through some other institution than committees. I'm not saying it's perfect, but we need to restore some sense of committee activity in substantive legislation.
To you and Chris's earlier point, I'll give you an actual example. Post office is broke, right? It's bankrupt. It's losing $5 to $8 billion a year. Tom Coburn led on this issue. We worked on it for 3 years. We got a bill out of committee. Harry Reid wouldn't put it on the floor. All right? Why wouldn't he put it on the floor? Because his campaign account is controlled by the unions. Unions didn't want the bill, even though it was a compromise of the Madisonian process in committee. Long hearings, lots of them, 20 or 30. A 2-day markup with all the amendments open, total open process, passes out of there with only 3 votes against it. And the leader won't put it on the floor, something that's draining the country every day. So, you're right. The Madisonian process is the way to do it. But if you have leadership that won't allow that process to work and doesn't want it to work, but for a political consideration, not for the best, and that's my big reason I left, is when you care more about politics than you do our country, whoa, that is a warning shot, and you just look at it. Watch it every day. Now, I'm not saying there's not great people there. What I'm saying is people are succumbing to their natural human nature rather than leading out of service.
Well, I think where I differ slightly from our panel, I obviously run to the problem starting with the courts. I think the courts have really are currently the main problem we're having in terms of the Madisonian system. But where I would caution is on 2 points that were already raised. One is, can we solve the problem with overreach of presidents by picking a better president? And that's a really dangerous way to think about this, that the solution to presidential overreach is to have a president who will save us from it. The problem is that we have presidents who act with discretion. They could be great or they could be not so great because they're unchecked, and so we have to deal with that. And the other thing which you raised, which is, well, can any of this really get done in the committee system? And I think we often portray with the framers in an accurate way. This Constitution was not just written for times like ours. It was written during times like ours. Okay, if you want dysfunctional politics, go back to when this thing was written. So everything you described existed. So what's the difference? The difference is they had to make the decisions. See, the difference is that all these decisions had to be made in Congress because they didn't have all these agencies. They didn't have all this deference. So as bad as they were, and they were no better than we are. I mean, we give ourselves a bad rap on this, but there were some really horrible people in Congress back then. But they didn't have a choice. If you take an example of the recent case, like the Arlington case, the Supreme Court just said that Chevron deference extends to an agency interpreting its own jurisdiction, something that we never thought could happen. That an agency not just gets deference on decisions, but actually gets deference on how broad its jurisdiction is. It becomes a perpetual, self-perpetuating machine. That's the problem, is that the members are able to kick this to agencies. And so if the courts apply a much more Madisonian approach and start to deny some of these powers, to get the powers cabined as they were, then no matter what these people may want to do in Congress, they will have to make decisions.
Let's thank Senator Coburn has to leave to catch a flight, but let's thank him for his participation. Well, it's 3:30. I think we're right on time, and thank you very much for coming.